Mr. Chief Justice, Justices of the Supreme Court, may it please the Court. My name is David Marvin, appearing today on behalf of the appellant, TES Filer City Station Limited Partnership. I anticipate I may use all this time answering your questions, but if there is any time left, I'll pay attention to the clock and I'll reserve it for rebuttal. You've read our briefs. I won't repeat them here.
Thank you.
You know my client's position in this appeal is that a rule change is implemented only when a rule has a practical effect on the entities to be regulated. But the MPSC disagrees, so I want to read you a short excerpt from an order that the MPSC issued after the briefs were filed in this case. On November 19 of last year, and I'm going to just focus on the key words, in a rate case for Consumers Energy, the Commission said, quote, Consumers Energy is authorized to implement rates that increase its electric revenues by $130 million on and after December 1, 2015. After the closing of a sale of the Jackson Power Plant, Consumers is authorized to implement rates that increase revenues by $164 million. On and after April 15, 2016, Consumers Energy is authorized to implement rates that increase revenues by $126 million. Quote, implementation of these rates will be in 3 steps, close quote. Now, my point here is not to get sidetracked into that rate case, but to point out that the Commission itself, which is taking the opposite position to my client in this case, used the word implement repeatedly in its recent order in exactly the way that we're suggesting here. The Commission was dealing with rate changes, and they had a plan that they approved to make rate changes.
I have no idea why that's relevant. None whatsoever. They can say they're a regulator, right?
Mm-hmm.
So they have the authority to say to their regulated entities, you may implement when we tell you. I don't see how that helps you with the statutory construction argument.
Well, Your Honor, that's a good question. The statutory construction
That's why I
argument,
asked it.
I will. The statutory construction argument that we have is based upon, I won't repeat them, but a host of cases and dictionary definitions that support our interpretation of when a rule change is implemented. And what I'm saying is the Commission in that case said that a rate change is implemented in exactly the same way that we say a rule change is implemented. It's implemented when it has effect.
My biggest concern with your construction is the rule talks about, or the statute talks about change. Change. You conveniently leave out in your construction, but costs that are incurred due to, you would leave changes in and read on federal or state environmental laws. My question here is, what changed after the statute came into effect? What federal or state environmental law regulation changed? As I understand it factually, the antecedent to this was something that occurred in, what, 2007? That the trajectory of everything that occurred after that was based on that change. Wasn't that right?
Not exactly, Your Honor.
What changed?
Okay. The standards that actually applied to my client changed November of 2009.
Changed in what way?
Prior to that time, they were not required to have their NOx emissions regulated.
So the 2007 didn't anticipate an effective obligation in 2009? That's what you're saying? We were surprised in 2009 that we had to do what was required then.
We're not claiming that we were surprised, Your Honor.
Why weren't you surprised then? Because in 2007, they said that's what you had to do in 2009, isn't it?
The change was implemented in 2009.
Just a moment.
The rule was...
Just a moment. I just want to understand factually before we start using the magic words implemented. The obligation that in 2009 you had to follow, wasn't that set forth in 2007?
Yes.
Okay.
So what you did, whatever it was that exactly you did to comply with the cap and trade program in 2009, were the steps that you took, were those the beginning or the end at 2009? I mean,
In terms of having our NOx emissions regulated, it was the beginning. That's the first time that we were subject to those rules. And just to be clear,
but I mean the steps that you did to comply with the new rule in 2009, were those steps over? Were they completed, or were they just starting? What, on your end of it?
our obligations continue to this day to have our NOx emissions regulated. And the key issue here with the term change is you have rules that have existed for some time regulating NOx emissions, NOx being nitrous oxides, for various entities. And over the course of time, different entities are being added, the allocation formulas are being changed, the standards are being modified. And so if you just were to, if the legislature were to have worded this saying that it's just when the rule changed, you're reading out the word implemented. You're just saying, okay, when the rule changes. But
Well, you
when is
really
that
about
change?
Tell me how change works with implement.
The change in the law, or in this case the rule, is one that says this is a plan. The rule is called an implementation plan. It is a plan to implement a change in the regulatory environment for various entities at different times. The newly affected electric generating units, and that's the term that applies under the rules to my client, those newly affected entities, that change applied to them in 2009.
But you were told about it in 2007, right? You're going to be, in 2007, the newly implemented, those subject to these NOx requirements were told in 2007, I think, that in 2009, you have to comply. Isn't that accurate?
Yes.
And then, then there's some process eventually, I assume, for determining the number of allowances you're going to need and purchasing those allowances, right?
Yes.
And that process, does that just, you wait to start that in till 2009, because that's when you have to comply, or what?
The 2007 rules, the majority of the rules were changed in 2009. The EPA, those rules were subject to EPA approval, as stated by the DEQ on their website and in the authorities I've cited.
So you didn't have to comply with them. You didn't have to even prepare, because the state of Michigan doesn't have independent authority to propound the change that it did in 2007.
That's a very carefully worded question, Your Honor. I have to be careful that you're not misled by my answer, yes or no. The rule that they actually promulgated in 2007 was clearly a SIP, a State Implementation Plan, with 32 incorporated references back to the federal plan, subject to federal approval.
Yeah.
It was not a standalone, hey, the state is deciding to regulate NOx emissions.
Everybody understands in this context that the feds control. But that doesn't mean that the state doesn't have its own independent authority to promulgate it, the rule it did, and the statute it did in 2007, 6, whatever it was. Isn't that right?
Well, yes, Your Honor, that gets us to the point that Judge Whitbeck focused on in his dissent, which is that those 2007 rules were rejected by the EPA, and by their terms, they became a nullity at that point, because the definitions that were incorporated into the state rule essentially said, as the DEQ says more plainly on their own website, it was issued subject to EPA approval. When the EPA rejected the rule, that turned it into a nullity, and at the time at which my client incurred the costs, the 2007 rules were a nullity, except in combination with all the amendments that were adopted in 2009.
But, Counsel, even putting aside the state implementation plan and whatever contingency that had, wasn't there a default federal implementation plan that even preceded that, and that was basically promulgated by EPA for those circumstances in which a state implementation plan was not eventually approved? Wouldn't that plan by itself have imposed costs upon tests that would have taken effect whatever happened after 2008?
It could
In
have.
other words, they were bound by the federal implementation plan, weren't they?
My client incurred its costs due to, that's words in the statute, due to state plan. They did not incur them due to the federal plan. So again, putting all the words of the statute together.
No, but the point is, if what EPA did after 2008 had not been done, the default plan that was adopted, I think, that was imposed in 2006 would have already imposed those costs upon your client, wouldn't they have? So it can't be said that what happened after 2008 was responsible for imposing those costs, because they had already preceded that federal implementation by virtue of the default federal implementation that had earlier been enacted.
There are a number of components here, one of which is that the federal courts had actually vacated those rules before the October 6, 2008 date. That's the cutoff date in our statute. And then it was reinstated after that. The costs were not incurred due to the federal plan.
You're
And I
due
guess,
to the state plan, the state statute and the regs under that, right?
yes, as they were amended and approved in 2009.
Well, what was the change then? All right, let me understand. The state says, you got to do this. Your client starts doing that in 2007. So what's the change that occurred after that? The change in state or federal law, environmental law?
The change that occurred after that was the 2009, where the action of the federal government approving the rules as amended in 2009, and those being the ones due to which my client incurred the costs. I want to be careful.
Whoa. Your client had started incurring costs in 2007 in anticipation of complying with the statute and rules under it that were enacted then, right?
No, that is not correct.
Okay, tell me what happened once the statute and the rules promulgated under it said you got to have a NOx plan?
At that point, they said it's going to take effect in 2009.
And so your client did
No
nothing
preparation, no steps?
in anticipation of complying a couple of years later. Is that what you're saying? I thought you had said a couple of times here, and maybe I misunderstood you, that your client's costs were due to the state regulations. Is that not true?
They were due to the implementation of the state regulations. But the difference here is that, and the wording is very precisely chosen by the legislature. And if they wanted to say that it's costs due to laws that changed after this date, they could have said costs due to laws that changed after this date.
Costs that are incurred due to changes in federal that are implemented after the effective date.
Exactly. That is the key, Your Honor. The wording was very carefully chosen. If you take out implemented, if you throw implemented aside and say costs incurred due to changes in regulations, okay, it doesn't say that. It's changes implemented after this date.
Okay.
Counsel, can I ask you a question about, I've been worrying about or wondering about whether the Court of Appeal majority's interpretation of the word implement can have any broader jurisprudential, consequences that we should be worried about here. Can you identify any statutes that would make us worry about that interpretation because it would be wrong or disruptive or, it's a published opinion and they've now said pretty emphatically what interpretation means. Do we have to worry about it in other contexts? Because if it's just about your client, it's less, we're not going to worry quite as much. We care about your client, but.
No, I appreciate that. I think one of the things that's important for me to point out and to emphasize it, while this is of critical concern to my client and we're concerned with that manifest injustice, for purposes of this court, I think you need to look at the broader impact on the jurisprudence of the state. This particular decision, the split decision, the majority decision below, is a departure from prior precedent as to when a plan is implemented. Well, I have a host of cases I've cited and
But my
definitions.
question was, can you think of other, I've been trying to, can you think of any other statutes where this now, definition of what implement means is going to be disruptive or wrong?
I believe that the MPSC in its supplemental brief lists a number of examples. They claim that's an example of why you shouldn't do what my client wants, but I think those are examples of the statutes they list in their brief, where they say, well, gee, there's now going to be a question as to whether those are implemented when they actually affect the regulated entities or not. And it's easier just to say, oh, it's implemented when it becomes effective. All of those cases now, there's going to be a question. Let's say that there's a statute of limitations issue with respect to those, or if there's a compliance issue. When the change is implemented, it's different than when the change is made. That's the key. The way this is worded, it doesn't say when a statute is changed. It's due to when changes are implemented. And hence, all of the cases we've cited that make that important distinction.
Is there any difference in changes in a federal or state law being implemented and the federal or state law being implemented? In other words, would your arguments here be exactly the same as they are today if the word changes in did not appear in this law?
Interesting question, Your Honor, and I'm glad you asked that. Yes, there is a difference. If you look at the history of the rules, for example, just the NOx rules, there's a lot of other rules that you could look at, but the rules we're concerned with are NOx regulation. There were NOx regulations going back many years. There were changes. The rule, for example, Rule 801, was the only DEQ rule in 2000 on NOx regulations. It has been changed, and it has been changed, and it's been changed. The NOx rules were adopted in 2000. They were changed in 2002, 2004, 2006, 2007, 2009, and they're being changed again. Without the word change, and you say, well, when was the rule implemented?
What's being changed in 2007, 2008, 2009? The law's not being changed. What's being changed at those junctures?
Allocation formulas, numbers, filing requirements, entities that are being subjected to the regulations.
But I guess the premise of my question was, isn't the focus, as I try to parse the grammar as best as I can, the focus is upon the change in the law. The change occasioned or caused by the law, right?
The implementation of that change. There are, if you were to say, take out the word change and say, well, it's just going to be a question of when the law is implemented. Okay, now you put the word implemented in, taking the word change out. Now you have this situation where, when was Rule 801 implemented? Well, in 2000, 2002, 4, 6, 8, 9. Which one? It's the implementation of the specific changes to the law. Because it's not a question of this is a brand new separate rule number. I mean, some of them are new rules, but some are just the same rule being amended. The majority of the rules in 07, for example, were changed in 09. And 07 was a change from what existed in 06. So you need the word change and you need the word implemented. Take either one out and you have a different meaning.
Does any fractional change trigger this provision? And the exception to the cap? Any infinitesimally small change, they move a comma around in the regulation. Is that a change that affects the cap?
If it has not been implemented, I don't know that the changing of the comma would make a difference. So I would say not.
Well, let's
moving
say
the comma.
statute, that somebody goes back and makes a technical correction.
Isn't the answer only if it increases your costs?
Right.
I think that, yes, you
Are all your increased costs due to your participation in the cap and trade program
yes,
that are at issue in this litigation?
yes. This
Weren't those all
particular
in
one.
place in 2007?
One of the things, I think it actually even confused the PSC because they're not environmental experts, and nor was I before this, is that there was a NOx budget trading program in existence before that. I think it goes back to maybe 2000 or before. But that program was replaced, as the DEQ website that I've attached to my briefs points out, replaced by the CARE program. The CARE program is in the process of being replaced now by the CAPSR program.
But those costs were also imposed by the federal program, what I've described as the default program. If there'd been no state implementation plan at all, those would have kicked in, would they not have?
The costs Your Honor, I understand your point. The cost would not necessarily be the same. Otherwise, the feds would just say, well, here you go. The minor little changes in the rules affect how much the allocations are. I think it's 1,385 tons of nitrous oxides are allowed for 3 categories of newly affected entities in 2009. That's a closed pool. You don't know until 2009 when you apply for your allowances how many you're going to have and how many are going to be left, how many other people are going to have, what your costs are going to be.
If Michigan had withdrawn its own program, Tess would have still been obligated to incur the exact same costs under the federal implementation program, and that would have kicked in if Michigan had withdrawn or backed away in some respect from its implementation plan. Isn't that right?
That is not correct. It would be very logical to assume that, but it's not. And that's why you have this issue of implementing the change, because the state decides how many tons of a particular emission are going to be allowed to a particular class.
But the whole premise of the federal program is you can't force a state to legislate. The federal government doesn't have that authority.
Yeah.
So they put in something as a safety valve in case the state does not enact a program, or based on my hypothetical, if it withdraws its program, there is something in place that will achieve the federal purpose, right?
From the big picture, yes. But the key is, what are those costs going to be? There was a case that was attached to MPSC's brief involving the Midland Cogeneration venture. Very significant there, not so much because it happened to have some regulation in 07, because that dealt with a plant that was regulated in 07. But it's significant because the point was when the MCV, the Midland Cogeneration venture, filed for its NOx allowances, all of a sudden that cost the other applicants $4 million. Because you don't know till that day what the costs are going to be. That's what the legislature was struggling with. You have no idea what the costs are going to be. In that case that was attached to the PSC brief, that was a surprise to Edison and consumers because the MCV filed, and the way it was filed, $4 million more cost. You can have a situation where if you get the allowance allocation and not enough other people ask for them, there's no cost. You're given the allocation. It's when you have to buy others in the market that it costs money, and the costs for that are also uncertain.
I'm struggling to understand this, and I want to put to you the arguments interposed by both the PSC and the Attorney General. The PSC asserts, in setting the cap at $1 million per month, the Michigan legislature took into account the state of the law and existing environmental regulations at the time. And the AG points out, quote, those regulatory changes were put in effect in 2006 and 7. And, quote, each of the regulations contained on their effective date compliance schedules that required parties such as TES test to buy NOx emissions allowances in 2009. There's no basis to believe the legislature deemed those regulations a change. Is that an accurate statement?
Technically, no. And I can't fault them because this is a very complicated area. But it did not say you have to buy allowances. It says your NOx emissions will be subject to regulation. You will apply for the free allowances. If you get enough of them, there's no cost, other than the cost of writing a letter saying, please send us the free allowances. If it turns out that there are enough people competing for a piece of the pie that now you don't have enough, now you have a choice to make. Do you operate your plant at a level that's going to emit more than that? In that case, you have to go out and incur costs to buy allowances in the cap and trade market. And what are those going to be? Well, like the MCV case shows, it could be millions of dollars.
Thank you. Thank you.
Happy to answer any other questions.
Thank you.
Thank you, Your Honor.
Good morning. May it please the Court, Lauren Donofrio on behalf of the Michigan Public Service Commission. I'd also like to introduce Robert Reichel at council table, appearing for the Attorney General, with whom I will be splitting argument time. The Commission
manage that.
I'm sorry?
You manage that.
I will. Thank you. The Commission asks this Court to deny Tessa's application because statutes and regulatory schemes are implemented on their effective dates. This is essential because there must be one rule that applies equally to everyone in Michigan. When the legislature passed Act 286 in late 2008, electric utilities across the state were already incurring hundreds of million dollars in costs to get ready for the Clean Air Interstate Rule and Michigan's version of the rule, both of which had a 2009 compliance deadline. Why were they already doing this? Because it takes years to institute physical pollution controls. You have to conduct studies. You have to order the manufacturer of parts. You have to schedule system outages, and you have to actually install these things, and it takes time. The utilities did this so that they could avoid having to purchase NOx emissions allowances above their budgeted amount in 2009 when the deadline for compliance was. When the legislature stated that costs incurred due to changes in federal or state laws and regulations incurred after October 6, 2008, they were talking about new laws, new regulations, or changes to existing laws and regulations, not the ones that were already on the books. This must be the answer, because if implemented meant when a regulation has a practical effect on a particular entity, similarly situated parties would be treated differently under the law. I'll give you an example of how this interpretation would have dramatically different results for two similarly situated entities. One biomass plant, in response to the 2006 federal implementation plan and the 2007 state implementation plan, wants to avoid purchasing allowances for excess emissions and things that it'll have in 2009. So in late 2007, early 2008, it begins incurring costs. It conducts a study, orders manufacturer of parts, schedules an outage, installs physical pollution controls. A second biomass plant does nothing, and it waits until November 2009 to purchase allowances when its emissions exceed its budget. The 2009 compliance deadline had practical effect on these two entities at different times. One before October 6, 2008, and the other after. The legislature cannot have intended for the first proactive plant to be subject to the cap, and the second plant that did nothing not to be subject to the cap. Rather, the legislature must have used the word implemented to refer to the effective date of the statute.
Why must that be the case? Why, I mean, I have difficulty, whatever else, the dissent in the Court of Appeals makes a pretty compelling argument that enacted is not necessarily the same thing as implemented.
Well, I would agree that it's not.
Well, why is it then here? That's the rationale, essentially, of the PSC and the majority, isn't it?
Well, no, and this is an error that the dissent makes. The dissent argues that...
Isn't the PSC's position that the effective date is the implementation date?
Yes, the effective date, but
Why
you said
are those
enacted.
the same thing?
Because enacted is not the same thing as effective date.
Okay, but if you had a statute that was enacted and the legislature said to become effective immediately upon enaction, then we'd be in this situation. And then you would say...
What?
They happen to be the same date, yes. But that is not always the case.
Implementation is the same as enacted date.
Not always.
Well, but, okay, we just...
Implementation is the same as effective date.
It is, yes. And that's important because, and that's the difference between promulgated and effective, because when something is promulgated, that's just the final step in the process, whereas effective date is a conscious choice that the legislature makes to set a date that it thinks is appropriate for implementation. And that is the effective date of the statute.
But then why
are
does the statute use the words implemented and effective date in the same sentence?
Yeah.
Likely
So
because it would have been
regulations that are implemented after the effective date.
after,
why doesn't it-
after the effective date of Act 286.
But in your view, those are synonymous. Implementation and effective date are the same
They are,
date.
yes. And I think
Why?
it would have been very
Why?
confusing had
Just
the
a moment.
legislature used effective date twice within three
Justice
words.
Larson just pointed out that there obviously are two meanings. Otherwise, they would have said, they wouldn't have used effective date and implementation.
Well, I think the reason that they didn't use effective date and effective date is because you would have had effective date within after the effective date of, and it might have been very confusing to read that sentence using effective date twice in such a close proximity to each other within the sentence.
They used effective date because that's what the legislature typically does. They use effective date.
Well, they do, yes.
In
And
fact,
that's
they
something
used
that the
word
legislature
effective in the very
knows.
statute that we're talking about here when they made the effective date the same as the enactment date, right?
In this case, they did,
used
yes.
the word effective.
They used the word
They
effective.
also
yes.
used implementation, which suggests,
Implemented.
implement.
Implement.
They could have used implementation, and then it would be quite clear, right? If they were to be the same, it could have been implemented after the implementation date of MCL 460.6A.
They could have done a lot
That's
of
all.
things.
Yeah, right.
But they didn't. And we're left
And
with
Yeah.
figuring out what they meant.
I'm trying to understand why the PSC construction gives meaning to both words.
Well, it does because if you look at the word changes, changes are important. You almost don't even have to get too implemented if you remember the fact that there first has to be a change, right? There has to be a change in the law or the regulation.
Because we're now in the deep end of the PSC world, and opposing counsel has made the claim, well, there are all these changes. There's nothing that's been constant in this
World
universe.
of PSC is nothing but a world of change.
Yeah, and I read what both the PSC and the Attorney General claim the state of the world is, and he said, well, that's technically accurate. So I'm trying to understand what is a change in this context.
Sure. A change would be a different obligation. So let's say the 2007 rules didn't say that TES was going, or TES was going to be participating in the budget trading program. But then in 2009, changes happened in the law that said TES is going to be subject. Well, then that's a clear change. There's a change in the obligation.
How about how much, the formulas, those that
The
affect
formulas
TES?
aren't part of the law or the regulation.
They're not?
They are not. The way that the formulas work is part of the application process, which is governed by the rules and the regulations, and those aren't codified that way. Well,
do
I
they
guess I
have the
shouldn't
force
say
of
that.
law
That's not
then?
entirely correct. It is very complicated. There is a overarching formula, yes, and those formulas didn't change as far as what TES's obligations were going to be. The
claims they
changes
did.
between the 2007 and the 2009 were typographical and one clarifying statement. They did not make any changes to Rule 803.
How about formulas under them?
My understanding is that there were no substantive changes at all, and that is stated in the EPA's approval of the 2007 and 2009 rules.
Council, good morning. What I'd like to get a sense of is there's so much going on here. If I was to write an opinion on this, what is the takeaway? Like, what exactly would the takeaway be as it pertains to how companies like DTE and TES are supposed to conduct themselves as it pertains to these regulations? You know, what would you like an opinion to look like, and how should it be written in such a way as to give clarity to this subject?
I think that it should clarify to say that unless the legislature specifically says it means something else by the word implement, but when the legislature uses the word implement, it means the effective date of a statutory scheme or a regulatory scheme. Because otherwise, there is no certainty. There's no certainty because when the statute has a practical effect isn't determined by looking at the law. It's determined by the decisions that a particular plant or entity makes.
Well,
And
wait,
there's no objective way to measure that.
Why isn't the date on which they would be subject to some force of law sanction if they didn't comply?
Well, we're talking about compliance deadlines. They were allowed to voluntarily participate earlier.
Sure.
And most entities were already incurring costs by October 6th of 2008 to get ready for this.
Sure, but not under compulsion.
Well, it is somewhat compulsory because it takes time to do these things.
Well, yes.
So on the first
So they
day,
could have just sat there and done nothing, and then on the date in 2009, the hammer would have come down and they would have been in trouble.
Right.
But so the costs were prudently incurred beforehand, but there was no obligation of law requiring them to spend one dime before 2009.
Well, that's actually not true, and the reason is
Okay,
this.
explain that.
When a utility that's regulated by the MPSC seeks to recover any costs that it incurs and impose those costs on ratepayers, they have to be reasonably and prudently incurred. And if it were to not prepare to comply with environmental regulations and just wait when it would have been prudent not to do that,
Yeah.
and tried to recover the penalties, the answer from the MPSC would be no.
But that would be a ground for denying their application to recover the costs,
It would.
but that wouldn't necessarily mean, so they might not be, but that wouldn't affect necessarily the way we read the word implemented. You might say, well, the law was implemented as to this company in 2009. They applied to recover the costs under the statute. They don't get to because they didn't act reasonably and prudently. But that doesn't go to the meaning of the word implemented. It goes to whether, for other reasons, you want to deny their application.
I understand what you're saying. I mean, the way that we look at it is that from a regulatory standpoint, these statutes and these rules compel action when they come into effect.
Counsel, can you help me with what I asked?
If you want to give the AG any time.
Yeah, I was about to
Okay.
say,
I'll ask him, that's fine.
I'm
Yeah.
sure Mr. Reichel would be more than happy to
problem.
answer your
Great.
question.
Thank
you.
Good morning, may it please the court. Robert Reichel, Assistant Attorney General, appearing on behalf of
Now,
Yeah,
Justice
you are the
Kavanaugh.
right guy for this question. Have you thought any about whether we should have broader jurisprudential concerns about the majority's interpretation of implement? Are there other statutes you can point to that should make us feel comfortable, that should make us think, yeah, they nailed it, nothing to worry about here. This isn't going to be a problem in the next 5 cases. We can see it in some other context, not.
I understand, Justice McCormick. The short answer is no. I do not see that this case presents, or the Court of Appeals' construction of the term implemented is one of broad jurisprudential significance.
can I come at that same question? Suppose I am convinced that the construction of the majority conflates those two terms, that they are not synonyms or the same. Can you still win?
Well, I would respond, I think we can.
Okay, then I want to hear that argument.
Okay. First of all, contrary to Justice Whitbeck's dissent, the majority, in this case, specifically indicated they were not equating those two terms. And in fact, it's very important to note that both the majority and the dissenting opinion relied, in the absence of a statutory definition of implement in this statute, relied upon the same dictionary definition, which included the phrase, to put into effect. That is that is the analytical framework that I submit is consistent with this, broadly speaking, with this Court's jurisprudence and the statutory provision dealing with construction of undefined statutory terms. So I don't think it is accurate to say that in this case, the majority departed from any established jurisprudential.
But what if I disagree with it? What if I think that they are conflating the two?
Well, I think that it's critical in looking at the decision below that we're focused on the interpretation of a very specific statute, the one that we've been discussing here, 6A8, which has been noted and is reflected in the papers, talks about changes in state or federal environmental law or regulation implemented.
The majority didn't focus on changes in terms of its analysis and its conclusion.
Well,
I think that's a critical omission. I think that is the fulcrum that permits the PSC to get to the conclusion and the majority to get to the conclusion it reached.
Well, I think if you go back to
Is that wrong?
No, I don't think it is. I don't think the Court of Appeals ignored it, but for purposes of this court's consideration, do you have a jurisprudentially significant issue? Does this merit granting leave?
It's a published opinion.
I'm sorry?
It's a published opinion, and it has an impact on a fairly significant sector of the energy community, does it not?
Of course it's published, and it is precedential with respect to...
That makes it more significant, does it not?
But the issue that you and Justice McCormick have been asking us about, what about the interpretation of the word implemented? I think that both the Commission, looking at this statute, reading the statute as a whole, changes in law or regulation implemented after the effective date of the statute we're construing. We're looking at the basic question.
Were there changes after the law became effective?
No, not substantive. As it relates to the issue that brings us here today, TES Filer City spent money it had to comply with beginning in 2009. It had to either reduce its emissions of nitrogen oxide or buy allowances to continue to emit it. That obligation was fixed both in 2006 under federal law and then in 2007 under state law in the respective regulations. The substance of that obligation to either reduce your emissions of NOx or nitrogen oxides in 2009 did not substantively change. Yes, there were some definitional changes.
Did the PSC make a determination that there were no changes within the meaning of the statute in this case?
I think that, yes, I'd have to look at the order again, but I believe the substance, or at least as I read the Commission's order, it said in effect nothing that changed, or that they had, TES had failed to demonstrate.
What deference do we give to that determination if it was in fact made?
With respect to their opportunity to consider the record as to what the state of the regulation was, I think they have some expertise in that, and certainly with respect to the implementation of a statute they're charged with, the construction of the statute they're charged with implementing. That really, as to the PSC has technical expertise. It created an evidentiary record, and it concluded, it focused primarily on the legal issue.
I assume that you're making an accurate representation about the finding. My question is, what deference do I owe that determination?
The standard review of Public Service Commission actions that their orders should be upheld unless unlawful or unreasonable.
Can I ask you to pursue a question I posed to Mr. Marvin earlier when I was asking about the relevance of the changes in language? To me, the understanding of what implemented means is at least in part a function of what those two words mean. By changes in, are we talking about changes within these state or federal laws, as to which there may be many changes, some of which will be implemented in 2016, some of which may be implemented in 2017 or 2018? That would be what would result if changes in was referred to changes within. Numerous changes within a law might be enacted, some of which might be implemented today, others of which might be implemented tomorrow. But alternatively, changes in can refer to the change in the law itself, to the change from what the law was yesterday to what the law is today. In that context, it seems to me implement might mean something significantly different. What does changes in mean in your view? Is it necessary to this law? Is it superfluous or surplusage? Or is it essential in distinguishing this law from what it might have been if the word changes in were not here?
I think the answer to your question, Justice Markman.
Do you understand my question?
I believe I do. And I think the short answer is, reading the operative statutory language as a whole, all this is, we're having this discussion because the legislature established a limited exception to this cap on recovery of certain costs for costs incurred due to changes in state or federal law or regulation implemented after the specified date. So it is there's a cause and effect relationship. If the federal and state regulations, the changes in them did not, if there was not a change that affected the costs that were incurred, then they would not be
You're
material.
not answering my question
I'm sorry?
exactly. It does change refer to the fact the law itself has been altered from one day to the next, or is it referring to the changes that are made by that law, the myriad and various changes that are made by that law? There may be 50 changes made by a law, some of which will be implemented at this time and some of which will be implemented at a different time.
I believe that it's properly read, as it was by the commission and the court below, as changes in the law.
That doesn't,
That's what it's.
I'm sorry. I mean, it's the former of your two. If I understood your question correctly, I apologize if I'm not you posited two alternative constructions, and as I understood them, it would be the former, not the latter.
Is it referring to a single change almost invariably, which would be the alteration or the enactment of the law, or is it referring into what is what the law is comprised of and the different changes that are within the law that are enacted when the law itself, the larger law itself, is enacted?
the former you said.
I'm sorry?
I thought you said the former, not the latter.
Correct.
I guess I'm not articulating as well as I can, but
I apologize,
to me,
Justice
it's very
Martin.
significant in understanding what the subject of the sentence is and then trying to relate it to what the natural and reasonable meaning of what the word implemented would be.
I know.
Thank you very much.
Thank
Okay,
you.
submitted, we'll return 12:30.